Hello, this is Alexander Cross, attorney with Law Offices of Cross & Associates. If you'd like to learn more about criminal defense, be sure to subscribe to our channel, Law Offices of Cross & Associates. Be sure to ask some questions. Regardless, we received an interesting inquiry here on our YouTube channel. This has to do with the report of a theft. My son and his friends came in to steal at a liquor store. I know there are cameras and I think they will recognize my son. How can I protect my son? Well, it depends on his age. First of all, if he's a juvenile, that would help tremendously, because in juvenile court, it's not about punishment, it's about rehabilitation, and it's very possible that as a mother, if you are willing to take care of him, if you're willing to supervise him pretty extensively, he can be released on a GPS monitor so that you can keep him at home. Of course, he can't leave because your home is going to be the jail, but nevertheless, that's an option. However, if he goes to adult criminal court, it's a whole new ball game. First of all, let's talk about the conspiracy aspect, because there were 3 of them, so there could be a charge for a violation of Penal Code Section 182, felony, carries up to 3 years state prison. But of course, the big charge is the 211, or maybe even the 212, which would be violations that carry anywhere from 5 to 6 years of state prison. In a situation like that, if there's video of the incident, if he clearly committed the offense, you hear his voice, you see his video, he did it. In a situation like that, best course would first be to ask the court for a psychological evaluation under Penal Code Section 1368 to see if maybe this youngster was so absent-minded that he didn't understand the consequences of his actions, and is also still too absent-minded to assist in his own defense. However, if 2 out of 3 psychiatrists say that he's fine, well, then that's not going to fly, and it's going to be necessary at that point to discuss the matter with the DA's office. I mean, whenever they have you cold, whenever they clearly have the evidence against you, it's your funeral to go to trial. Because if you go to trial, and if 12 people from the community find you guilty of the crime, you could be looking at the potential maximum sentence for the offense, which, like I said before, is 5 to 6 years for the robbery, 3 years for the conspiracy. It's not a good thing. But definitely, to protect your child, he would need to remain silent, and definitely contact an experienced criminal defense attorney so that he can get additional counsel, and also so that the attorney and his staff can thoroughly investigate the case, because in a situation like this, especially if there is clear evidence, it's going to be necessary for the attorney to have very fruitful discussions, I'll say, with the DA's office to avoid a harsh punishment. Regardless of that, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross & Associates. But if you have been accused of a crime, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. See you in the next video.